Misconception number one, only the rich and wealthy need estate planning. That's not true, right? Like, if you're listening to this podcast, you probably know that's true. That's why you're listening to it. And that's why you might be interested in it, because you want to learn something about estate planning. What is true, that estate planning is beneficial for everyone, right? Anyone that has assets, which is almost everyone, and anyone that has dependents or children or people that they want to have those assets go to, which is pretty much almost everyone, would benefit from estate planning. And estate planning ensures that your wishes are honored. It reduces conflicts in the family. It can avoid financial complications or legal complications.
You are listening to the Legacy Talk podcast hosted by James A. Jones,
attorney at law and founder of Sound Legacy Law, PLLC in Tacoma.
Attorney Jones is here to talk about how to best protect your family, assets, and wealth. Pulling stories from his more than 20 years of helping families and business owners protect their assets, create their estate plans, preserve their wealth, and plan for the future. Nobody wants to think about estate planning, but life has a way of sneaking up on you, and at any moment, something unexpected could happen that will leave you regretting not having acted sooner. So join Attorney James A. Jones in the Legacy Talk podcast, and together learn how to plan for your future today and have peace of mind tomorrow.
Welcome to Legacy Talk. I'm your host, James Jones. I'm an estate planning attorney in Tacoma, Washington. I've been practicing for over 20 years, and my main practice areas include estate planning, probate, and estate administration. On Legacy Talk, we discuss topics surrounding families and estates. Estate planning can often be a confusing and complicated topic, but my goal with this podcast is to make it accessible and understandable for those who need it. So if this is something that interests you, I'd appreciate it if you click the subscribe button and like this episode so that we can together break down the barriers to estate planning. I'm excited to get to today's topic. Today's topic is Debunking Estate Planning, the Intricacies of Wills and Trusts. Because I thought we should get back to basics about wills and trusts. Sometimes we get a little bit complicated in this. I think maybe we can get into complicated topics that are not maybe as accessible. And so I thought, let's bring it down. So today, on today's show, we're talking about debunking estate planning, the intricacies of wills and trusts. So let's get to it. Wills and trusts, that's basically the two components that we talk about most in estate planning. Does anybody even say, I need to get my estate planning done? I don't think so. I think most people say, I got to get my will done. Maybe some people say, I want to get a trust done. Is just having a will and estate plan? Sort of, but not necessarily a complete one. But it's a start, and we want to start where we are and where we can. And so if that's all you can do is a will, that's better than not having a will. But that's not really what we're talking about today, is it estate planning in general. I thought for today's episode, we'd get back to the basics a little bit. We'll talk about trust a little bit. We'll talk about wills a little bit. We won't talk about other estate planning documents like durable powers of attorney or healthcare directives or anything like that, because we're really just talking about the basics. And knowing about the basics is important because knowing about the basics is empowering. And the reason, like I say at the beginning of each podcast on Legacy Talk, the purpose of the podcast is to break down the barriers to estate planning and to make it understandable and accessible. And so hopefully with the podcast, as we record and release podcasts every week, hopefully these are accessible. Hopefully the topics become more familiar and don't create barriers to getting these things done because they're important. And so if that's what's happening, good. And I know I'm an estate planning attorney. I've been doing this over 20 years. And this topic, you might not believe me on this. It's not the most interesting topic for entertainment purposes, okay? It can be dry, right? And so we like to keep it a little lively every week, I hope. Maybe a little bit of laughter once in a while, maybe. We don't want to have people falling asleep at the wheel after all. We want people staying awake and engaged. So let's get to it. Let's debunk some estate planning and get into the basics of wills and trusts. So I want to start off with the basics. What is a will? Right? Most people know what a will is, I hope. But those of you who don't, it's basically a legal document that dictates how someone's assets and property will be distributed upon their death. And the will allows individuals to name beneficiaries for their stuff Name someone that would be in charge of administering that stuff. Name guardians for their children and specify final wishes. Okay, so pretty simple. Who gets your stuff? Who's in charge of your stuff? Who takes care of the kids? Right? I testify that this is true, right? I mean that this is what I want. It's signed specifically with purpose in a certain way to make it a will. And then you have a will, okay? What is a trust? A trust, unlike a will, is a fiduciary arrangement between three parties. A trust allows a trustee to manage and distribute assets on behalf of beneficiaries. The third party to a trust is a grantor or trustor. That person sets up the trust. The trustee is the person that's in charge of the trust, in charge of running the day-to-day and distributing assets and stuff. The beneficiary is the one that gets the stuff, right? Benefits from the stuff. And trust can be used for various different purposes, like avoiding probate, providing for minor children. There's a million different kinds of trusts we've talked about. They can also manage assets for people that can't do it themselves. And so that's basically what a trust is. It's a fiduciary agreement between three parties to manage an asset. Okay? And like I've said before, for a revocable style trust, most people have, the three parties are the same person or people, right? If it's a single person, the person that is the grantor setting it up and the trustee in charge and the beneficiary receiving the stuff is always, or in most cases, the same person, or if it's a married couple or whatever. So that's the basics, okay? Wills and trusts. Some common misconceptions about wills and trusts are this, or estate planning in general, because we're debunking estate planning. Misconception number one, only the rich and wealthy need estate planning. That's not true, right? Like, if you're listening to this podcast, you probably know that's true. That's why you're listening to it. And that's why you might be interested in it, because you want to learn something about estate planning. What is true, that estate planning is beneficial for everyone, right? Anyone that has assets, which is almost everyone, and anyone that has dependents or children or people that they want to have those assets go to, which is pretty much almost everyone, would benefit from estate planning. And estate planning ensures that your wishes are honored. It reduces conflicts in the family. It can avoid financial complications or legal complications. So it's a good thing, right? Misconception number two is that estate planning is only about distributing assets. And while that partially is true, that estate planning is often mainly about distributing assets, it's not just that, right? Estate planning can also help deal with incapacity issues. Those other documents that I said we wouldn't talk about today, like healthcare directives. It can appoint guardians for children. And so there's other things that it can do, right? It's not just about distributing your stuff. It's about making sure that you contain or maintain control during your lifetime, where someone has control over your affairs if you're not able to manage them yourself. So it's not just for the wealthy, and it's not just about asset distribution. The third thing we want to talk about with wills and trusts is probate is the legal process for validating someone's will when they pass away, right? And overseeing the distribution of their assets through a court proceeding called probate. And probate, while it can be an orderly and sometimes very beneficial process, it can also be a process where you're taking a lot of time and you're costing a lot of money and you're going through a lot of hoops that you may not otherwise want to go through. If you want to learn about the good about probate and the bad about probate, there's episodes that are on those topics. I think the most recent, one or two of the most recent episodes was about the bad things about probate, why we want to avoid it. So check that one out, 32 or 31. With a will, you're going to be going through probate. Okay, when you have a will, you're going to be going through probate. Unless you don't have assets subject to probate. Like with beneficiary designations, you don't have real estate. If you have very small estate, you might avoid probate, even if you only have a will. With a trust, assets in a trust avoid probate. And so those assets avoid probate because the trust is the owner. And the trustee of the trust has authority to deal with those assets and doesn't have to go talk to a judge to get authority. Okay? And so they generally don't go through probate, which is more efficient typically, and it's simpler in most cases. And it, in most cases, saves time, reduces costs, just makes the process better. Okay, so it's better for the beneficiaries typically if you can avoid probate. So a will versus a trust there, the trust will be better as far as distribution goes in most cases. A will and a trust both can provide flexibility and control of assets. Wills provide clear instructions for asset distribution, but are limited in flexibility after death. Okay? So once a will says, I want my estate to go to Johnny, the estate goes to Johnny. Okay? And that's it. And after you're gone and the estate's been distributed through the probate process, Johnny does what he wants to do with that property. If all your will said was give everything to Johnny, or give whatever to Johnny, Johnny at that point does whatever he wants. Okay? So there's no control there. With a trust, oftentimes, and you can do this with a will, and we'll get into this a little bit, oftentimes the trust can offer more detailed control of assets and how they're distributed. For example, like a trust can say that certain assets aren't going to be distributed to beneficiaries until they reach a certain age or reach a certain level of education or milestones in their life, like graduating college, or if they got married, or if they want to buy a house or something like that. And so the trust, having assets placed in trust, so if Johnny had his beneficial interest in the estate, his inheritance placed in the trust, then that trust could sort of put parameters on the use of that property. And if Johnny's a minor, someone else will be in charge, right? Or if Johnny's not great with money, that trust can offer asset protection too. And so there's lots of benefits there. Those trusts can be created by trusts, or they can be created by wills. Okay, let's talk about privacy. A will and a trust both offer distribution of assets. They both offer flexibility in some degree. They offer a plan, a controlled plan, right? But with a will, there's not as much privacy. Because why, right? We just talked about it. Wills have to go through probate. And so once a probate is opened, a probate is a court case. And court cases are public record. And so once a will enters probate, it becomes public record. And that probate process typically requires that a personal representative or an executor files an inventory and says who gets what, right? And so all of that's public record, so Sally next door is going to come over and look and see what Johnny's getting. A trust, on the other hand, is a private document. And the reason why is because it doesn't go through probate. So the trust is only known to those who are managing the trust and benefiting from the trust. It's not known to outside parties. It's not known to courts, anything like that. And so it's private. So the details of your estate and your beneficiaries are confidential. And so this is only shared with people that either need to know or you want to know because they're helping you in some way, right? And so this privacy can help protect financial information. It can reduce the risk of disputes, particularly for people who are not included in the trust. So pretty good. Yeah. Guardianship of children. So we mentioned this a little bit to start. One of the things a will can do is provide for guardians for minor children. And trusts don't do this, wills do this. And so it's crucial for people that have minor children to make sure that those minor children have guardians. And the guardian's job is to make sure that child is taken care of, right? That their needs are met health-wise, financially, in certain cases, that they're getting their schoolwork done. Like they're basically watching these kids, raising these kids, making sure they turn out okay, right? Making sure that they're cared for right, all that stuff. So that part of it goes through the will. If you have minor children, and we just talked about this for Johnny's share a minute ago, that minor child's share cannot be handed to the minor. And the reason why is minors can't have assets without someone helping them, right? We've talked about this before. Parents named on minors' bank accounts are there because the minor can't have the bank account without mom or dad on there. And so the same is true for other assets. So if you passed away and you have minor children, you want to make sure that those kids have access to the funds, but are unable to manage them themselves. So you name a trustee, you create a minor's trust, you name a trustee to take care of the money. That person sometimes is guardian. Usually I recommend it be a separate person, but it can be a guardian if that's someone you really trust. That trustee's job would be to manage those assets for the benefit of the beneficiary, the minor kids, help them go through college, help them have living expenses, have what they need, have a good life as good as they can. And that's something the will does, right? So every trust that we do that's a estate planning trust, like a distributable trust as far as like a revocable trust, okay? Like a central estate planning document trust, 99% of them have a will that goes along with it. For other kinds of trusts, we don't always put a will with it, but if it's your main central document, which is typically a revocable trust, you will have a will. And oftentimes it's because you have minor kids. Some other things to consider when you're talking about your estate And this is sort of like a smattering of different things this episode, it turns out. Some things to consider when you're doing your estate is, how you're going to deal with blended families. Oftentimes people be in second marriages or have kids from previous marriages or whatever, previous relationships. And oftentimes a trust will be better for that because you can sort of dial in what's going to certain people a little easier than through a will. And there's less hard feelings because it's not going through probate oftentimes. And so that's something that a trust is pretty good at. A will is not quite maybe as good. Business owners, succession planning is essential for business owners. And oftentimes that's better through a trust as well because you want to make that asset not have to go through the public eye, particularly if it's a successful company. Maybe you don't want your competitors to see what's going on and see that there might be turmoil in ownership and that has rumors spread that your business isn't going to survive or whatever because so-and-so passed away. So that's something that you want to make sure to deal with. And so the trust probably makes a better option there. And then, of course, trusts are better for an essential for special needs dependents or beneficiaries. If you have beneficiaries that have special needs or need to have programs to help them with medical problems or educational problems, or they aren't able to work because of a disability, a special needs trust is essential sort of to run that. Okay. And so that's where a trust comes in more than a will in that situation. And I've alluded to this before. So this next little topic is the living trust or inter vivos trust, which means a trust that was created during your lifetime, or a testamentary trust. Testamentary trusts are wills that are created through a will or a trust that only come into effect upon someone's death. Okay. They don't necessarily avoid probate, especially if they're going through or being created through a will during probate, but they do provide distribution. So we mentioned earlier, if Johnny gets assets directly to Johnny, then he's in the wind, right? Those are his. He can do whatever he wants. But if Johnny's parents said Johnny gets his assets subject to a trust where a trustee's managing them, then someone's watching that stuff for him, right? And so you can create that trust through a will called a testamentary trust. You're still going through probate in that case, but Johnny's stuff is protected. Alternatively, you could create a living trust during your lifetime that covers your benefits. That's a revocable living trust typically. Created during someone's lifetime, that grantor, it can be revocable or irrevocable if it's created during your lifetime. They're effective immediately typically. They're usually used to deal with assets during someone's life or at death. And these revocable trusts can also create testamentary trusts or resulting trusts. So Johnny's mom and dad could have done a revocable trust and said, when we die, everything goes to Johnny and Johnny's in the wind. Okay. So the same thing would happen as if there was just a will that said everything goes to Johnny, other than the problem about going through probate. But they could do a revocable trust that says, when we're gone, Johnny's share goes into a trust managed by a trustee and make sure that Johnny doesn't blow this trustee. And so that's where a revocable trust could create a testamentary trust. That's technically not testamentary because it's not created by a will. It's a resulting trust or springing trust. So that's the trusts and the wills. So pretty straightforward. I think where you want to start, like I said, to start out on this episode is start where you are, do what you can with what you have, right? Do what you can with what you have where you are. And so if you can't do a full-blown estate plan all at once, do a will, right? If you can do more, maybe you do a trust plan. But minimally, you want to have a will for what happens when you're gone. And I said no other documents, but durable powers of attorney are really important, particularly if you have problems with your ability to make decisions, incapacity. And so durable power of attorney is something you want to have. Other advanced directives like a healthcare directive are essential. The episode that's going to be released right before this one is about advanced directives and how they are important and critical for you. So while it's really good, ideally, to have this robust, complete estate plan with a will and a power of attorney and a healthcare directive and a revocable trust and all these things, start where you are, start with a will, start with a durable power of attorney, and build on it. Okay? These things can be built on, and they can be changed, and they can grow over time. So start where you are with what you have. Okay? And so that leads us to the story time. And so this is a pretty generic topic, and I do a lot of estate plans. I've helped thousands of people with their estate plans, and a real simple plan came to mind. So I had done this a few different times for different clients, but young couples, recent married, often want to make sure that, well, we don't have kids yet, but we don't have a lot of money, but we really think the trust is the way to go, this revocable trust plan. We really think that's the best way to go. But we don't want to always have to update this thing, and we don't want to have to spend a bunch of money every few years. Every time we have a kid, we have to spend a ton of extra money. And so what we've done in these plans is we'll put a provision in that says, well, we don't have kids yet, but if we do have kids, let's create a trust for them just in case, right? And so the will creates the trust, or the trust creates the trust. In this particular case that I was thinking of, they did a revocable trust as their base document. So their revocable trust had a provision that says, if we have any children, divide our estate into as many shares as we have kids that live or survive us at the time of our death. And so, and when you take those shares, put them into a trust for the kids, okay? And so each one of those plans like that would sort of create a separate trust based depending on how many kids there are, right? So if they have 2 kids, there's 2 trusts, 3 kids, there's 3 trusts. Anyway, this couple took the easy, simple, straightforward plan, which basically set up these kids' trusts for future kids that might be there. And that's always an option. So estate planning doesn't have to be ultimately complicated there. It just has to be done ideally. So that brings us to the something good segment, which is also in the news. I was searching today for something good, and I'm looking for timely things that are interesting. And, you know, for what people say about Taylor Swift, she does really some good things. And so I was reading today the story from Billboard that says that Taylor Swift is working to leave cities on her Eras Tour route a little better than she found them. The 34-year-old pop singer is taking her global trek in Europe, so she's in Europe right now, and she's continued her trend of donating to food banks along the way. And according to one charity recently in Liverpool, England, where she performed at Anfield Stadium, a recent contribution from the singer will take care of crucial gaps in their fundraising efforts, providing a full year's worth of meals. Like, think about that. Like, these organizations work all year just to have enough for the needs that their communities need, okay? And Taylor Swift basically said, here's a year's worth of funds. And it says, it's the most incredible gift, Rich Jones, the chief executive of St. Andrew's Community Network, told The Guardian. Because of rising prices, rising need, and falling donations, we've been having to subsidize our food ourselves for a long while. But it's fair to say that Taylor Swift has essentially paid our food bill for 12 months. And that gives us the breathing space to focus on fundraising efforts going forward, he added, on behalf of St. Andrews, which runs 11 food banks and offers long-term support in 8 community pantries. According to Rachel Biggs, a chief executive at Cardiff Food Banks in Wales, Swift also covered 10,800 meals with a discreet donation to the organization in honor of her single performance in Cardiff on June 18th. And though Swift doesn't publicize these donations, Liverpool and Cardiff are only 2 of the latest cities to report receiving generous donations from the 14-time Grammy winner on this Eras tour of hers. When she was here in North America, she gave to food banks in Arizona, Nevada, Florida that we know about that revealed that she had sent funding their way. And so, you know, she's also really takes care of her crew and her drivers and her, you know, staff that works with her. And so she's a really generous person. So that's something good, I think. I thought I would mention that. Something good for the week. And sometimes we get these weeks and they're bad, right? And we need something to lift us up. So there's good in the world. And despite what you might think about Taylor Swift, or she's getting too much publicity, or she's in the public eye too much, or I'm sick of hearing about her, it's nice to hear things that people do that are for their community and for others. And so that's it. That's it for Legacy Talk this week. Thanks for listening to today's episode of Legacy Talk. If you liked today's episode and would like to learn more, please like and subscribe for more great content. I've been your host, James Jones. To your legacy.
Thank you for listening to the Legacy Talk podcast by attorney James A. Jones. If you found today's episode helpful, we ask that you like and follow us on all major platforms so you don't miss out on the latest episode. If you have questions for Attorney Jones, reach out at info@joneslegacylaw.com or visit our website at joneslegacylaw.com. Join us again next week for another episode of the Legacy Talk podcast.